for the first time, the concept of union territory constitutionally comes under the 7th Amendment, with other amendments under the 7th Amendment. But union territory is given a separate treatment and not the treatment which is given to other federating states. So kindly see, there was no Rajpramukh for Part C states.
Yes.
That's your lordship, sir. Union Public Services, All India Services, and Union Public Service Commission. Lord, I would show from the rules that all these except DAS, Lord, which is class 3, class 4, etc., are all India services. Kindly park that, Lord, undisputed position on the side.
17, right? 170.
70, Lord, I'm sorry. Entry.
Union Public Services, All India Services, Union Public.
Yes, Lord, all are all India services under the rules framed by the President in proviso to Article 309 of the Constitution. And those rules provide for, Lord, all mechanism, appointment, posting, etc. But, my Lord, that I will come subsequently. My Lord had some.
Yeah.
No, I got the point.
Lord, your lordships would essentially be answering the question, my Lord, whether the term services would be hit by the phrase insofar as it is applicable to the union territory.
Yes.
Because, my Lord, your lordships are not deciding the question regarding the capital of the nation, and which will have far-reaching ramifications for the nation, my Lord. Therefore, slightly your lordships may require a historical background as to how Delhi was conceptualized and eventually constitutionally provided for in a different governmental framework. There is a different, my Lord, framework provided, and there is a history behind it. Lord, kindly come to, Lord, one judgment. Lord, I'm sorry, I'm reading this judgment at the outset, but it's not on the question. It's on question of Delhi. What is the significance of Delhi? And therefore, my Lord, thereafter I'll take your lordships to the, Lord, kindly come to para 2 of my written submissions. Lord, right now, your ladyship, my lords may kindly take only the written submissions. I'll not go beyond this. And there also, my Lord, I'll skip what is not relevant. Everything is relevant, but what need not be read. I'll my Lord, put it that way. Page 2, Lord, the judgment in Jagdish Sharan versus Union of India. The Justice Krishna Iyer's judgment, as the language would immediately, my Lord, make it clear. Para 10.
One minute.
Pardon?
Para?
Page 2, para 5, judgment para 10.
Yes.
Is a quotation.
Yes.
The capital city is not just a part of India. It is miniaturized India. A fact often forgotten by the administration in the field of culture and education, especially vis-a-vis regional minorities. It is megapolitan and people from all parts flock to this outsized city. But we cannot exaggerate this factor. For the presence of the farther regions like South and Northeast, population-wise is minimal and precarious. Sri Balakrishnan, the learned council, not the report, Balakrishnan report, not that Balakrishnan, insisted that university was sustained. Your lordship can skip. We may, then para 56, we may wind up by articulating the core thought that vitalizes our approach. Anyone who lives inside India can never be considered an outsider in Delhi. Look, the concept that people of Delhi has a right of will, etc., etc. Delhi is a cosmopolitan, not just cosmopolitan, it is miniaturized India. It belongs to the nation. It belongs to the entire country. Now, Lord, let's see, Lord. Now, kindly come to para 3. Historically, my Lord, why this would be relevant? Because your lordships would be examining the chapter of services. And when your lordship examines the chapter of services, your lordships will need the distinction between the historical part A states, part B states, part C states, and part D states. There was a distinction which was, my Lord, eliminated, and thereafter, my lord, now Delhi is formed not from part A and part B, but part C. The relevance I'll come to later. Kindly come to, my lord, historical background, para 8. It is submitted that Government of India Act 1935 recognized in the circumstances in which it was enacted three categories of components of erstwhile union, namely governors' provinces, federating Indian states, and chief commissioners' provinces. Kindly note here, my lord, at this stage, Delhi was a chief commissioner's province. It was not a federating state. Lord, this classification was reflected in the grouping of states of the Indian Union as part A, B, and A, B, C, and D states. After independence and after constitution came to be framed. Therefore, when the Indian constitution was enacted, there were four categories of states known as part A, B, C, and D. Lord, you'll have to take it from me that Delhi was part C state. There would not be any dispute on this factual problem. We differ on the interpretation of the Article 239 AA. This fact is not in dispute. Lord, before the Constitution came into force, and even before the independence, Lord, at the request of the Constituent Assembly, a committee was constituted. That was Patabi Sitaramayya. Lord, an eminent tall leader, my lord, of his time, my lord, an eminent Congress leader, my lord, just incidentally, he fought against Sardar, against Subhash Chandra Bose as a president of Congress and lost, though he was sponsored as a candidate of Mahatma Gandhi. But he lost, my lord, the Subhash Chandra Bose one. Nothing to do with the matter. My lord, I'm not reading the entire recommendations. Kindly see E. Center must have special responsibility for the good government and financial solvency of the for Delhi. This was, my lord, Delhi specific commission, and they say that Delhi being the capital, I'm not going into, my lord, the details which ultimately reached into this conclusion, but they say, the committee says, Delhi must have special responsibility because it's a capital of that, belongs to the nation. The nation is known by the capital. Now, my lord, the constitution comes into force, and your lordships may kindly see para 13 at the foot, article 1. India, that is Bharat, shall be a union of states. The states and the territories thereof shall be the states and territories specified in part A, B, and C of the first schedule. So, my lord, India comprises of A, B, C. But in the first schedule, A and B were states, the way, my lord, we understand, like Madhya Pradesh, Maharashtra, Karnataka, etc., etc. And Delhi was in part C. That fact, again, my lord, is not in dispute. Now, kindly come to, my lord, para 15 at page 5. Part C states had also been termed as centrally administered areas. They always have been, my lord, historically centrally administered, and that thread continues with variations till date. That's what, my lord, I'm trying to respectfully drive at. The part C state had also been termed as centrally administrative areas. Delhi, in addition to Ajmer, Bhopal, Bilaspur, Kurg, Himachal Pradesh, Kutch, Manipur, Tripura, and Vindhya Pradesh, was included in the list of part C states. But thereafter, kindly come to the next page, page 6, Government of Part C States Act. But there is some relevance, my lord, to this. This, my lord, now Delhi came to be governed for the first time by a statutory enactment made by Parliament, namely the Government of India, Government of Part C States Act. Upon Constitution coming into force, the Parliament enacted Government of Part C States Act 1951 in exercise of the powers under Article 240. With Section 21 of the said Act, a statutory provision was made for the first time for Delhi to have a council of ministers and have a legislature comprising of elected representatives. With Section 3 of the Act, a legislative assembly had been created for Part C states. Section 21 had demarcated the legislative power of the assembly of Part C states. Section 21(1) had provided that the legislative assembly of Part C state could make laws with respect to any of the matters enumerated in the state list or in the concurrent list. However, insofar as the Legislative Assembly of Delhi was concerned, the proviso to Section 21 had specifically excluded number of subjects from the legislative competence of the Legislative Assembly of Delhi, including public order, police, land buildings, municipal corporations, etc. My lord. Now kindly turn the page over, my lord, and come to para 22. My lordships would notice, my lord, I am skipping other paragraphs which may kindly be read, my lord, whenever your lordships find at leisure, my lord. But I am right now not troubling your lordships with that. Para 22. Further, the proviso to Section 36(1) of the Act inter alia had provided that in cases of difference of opinion between the Chief Commissioner, not the earlier version of the LG, and his ministers on any matter, the Chief Commissioner shall refer it to the President for decision and act according to the decision given thereon by the President. Pending any such decision, the Chief Commissioner in any case of urgency was duly enabled, empowered, and could take such action or give such direction as it deems necessary. Lord, this is the counterpart of Article 239AA, sub-Article 4. Slightly differently worded, but in substance, that is what it says. Lord, thereafter, my lord, the Parliament appointed Justice Fazal Ali Commission. Please see para 24. In 1953, Fazal Ali Commission was charged with the task of reorganizing the states on linguistic line by the then Prime Minister. In the year 1955, the Commission submitted its report. Lord, so far as Delhi is concerned, kindly come to para page 10. What Justice Fazal Ali Commission remarked with respect to Delhi, which, please do not bear in mind, continued to be Part C state, not a full-fledged state, which it is not even today. But there is some other significance of it being a Part C state. Therefore, my lord, I am reiterating and emphasizing. Lord, page 10, your lordships have. Para 27. Lord, what? There are other, my lord, things also. Lord, I kindly come to, my lord, page 9 first for a, my lord, time being. Para 285 of the report. Taking all the, my lords have taken. Taking all the facts into consideration, we recommend that the component units of the Indian Union be classified into two categories: states forming primary constituents units of the Indian Union, having a constitutional relationship with the center on a federal basis. These units should cover virtually the entire country, and territories which, for vital, strategic, or other considerations, cannot be joined to any of the states and are therefore centrally administered. Please see the thread which is running historically from the beginning, that there are certain areas which are so strategically located for various reasons. In some areas, defense strategic. For some areas, it may be some external affairs issue. In a capital like Delhi, it's a capital, therefore has its own strategy. And therefore, they say directly the center should administer. And therefore, my lord, I keep repeatedly insisting that UT is nothing but an extension of union. It may have various shades. Some UT may have legislature, some UT may not have legislature, but ultimately the supremacy and control of the state is not only the need of the hour, had always been thought to be so. Now kindly come to, my lord, Delhi. Justice Fazal Ali Committee, my lord, what it feels about Delhi, page 10, para 27. With regard to Delhi and its status as the national capital, it had been specifically observed by the Commission as under. It is hardly necessary to discuss in any detail the reasons why Delhi, if it is to continue as the union capital, cannot be made part of a full-fledged constituent unit of the Indian Union. Even under a unitary system of government, the normal practice is to place national capitals under a special dispensation. In France, for example, there is a greater degree of central control over Paris than over other municipalities. In England, I'll come to that, my lord, if need be, my learned colleague, Mr. Faras's submission. In England, the police administration of the metropolitan area is directly under the control of the Home Secretary, who does not exercise similar powers in respect of other municipal areas. Apart from reasons which are peculiar to each country or city, there are some general considerations necessitating special arrangements in respect of national capitals. Capital cities possess or come to possess some degree of political and social predominance. They are seats of national governments with considerable property belonging to these governments. Foreign diplomatic missions and international agencies are located in these capitals. They also become centers of national culture and art. So far as federal capitals are concerned, there is also an additional consideration. Any constitutional division of powers, if it is applicable to units functioning in the seats of national government, is bound to give rise to embarrassing situations. Practice in other countries, administrative necessity and desirability of avoiding conflicting jurisdictions all point to the need for effective control of national governments over federal capitals. It may be recalled that the desirability of excluding the seat of central government from the jurisdiction of a provincial government was one of the main considerations which led to the transfer of imperial capital from Calcutta in 1912. Lordship may skip the rest, 589. It is conceded that the national capital has to be under the effective control of national government, and both New Delhi and Old Delhi have to be treated as a single unit for administrative purposes. There will be a little scope for difference of opinion on its future administrative pattern. Lord, kindly turn the page and come to page 591. In devising a system of government for Delhi, therefore, we must take into account primarily the requirements and aspirations of cosmopolitan urban population. Urban problems such as slum clearance, reconstruction, city planning, recreation, transportation, and primary and secondary education all fall within the domain of municipal finance and enterprise. If we were to guide, we are to be guided by these clear considerations as well as by the experience of other advanced countries. Municipal autonomy for Delhi in the form of a corporation would appear to be the most appropriate method of meeting and reconciling the broader requirements of the national government as well as the local needs and wishes of the people. We have given careful consideration to the argument that a denial to the people of Delhi of the benefits of popular government at state level would be a retrograde step. It has to be realized that if Delhi is to continue to be the seat of central government, it must adopt a model which is sound in principle and administratively workable in practice. People residing in national capitals enjoy an advantageous position and they must be prepared to pay some price for it. It may be pointed out that the legal residents of the District of Columbia in USA, are at present totally disfranchised. Then they say that that should not happen. Last 3 lines. We are definitely of the view that municipal autonomy in the form of corporation, which will provide greater local autonomy than is the important federal capital, is the right and in fact the only solution to the problem of Delhi. Thereafter, final recommendations are given in the similar terms. Now comes the Constitution 7th Amendment. For the first time, the Constitution is amended based on the report of Justice Fazal Ali Commission. And the concept of union territory comes, and this is very, very relevant. For this reason, when your lordships would examine the constitutional provisions, particularly with respect to services, your lordships would find that there are several amendments made through Constitution's 7th Amendment. the constitutional amendments have made provisions by way of amending service provisions, but there is a conscious decision to keep the union territories out. To put it differently, for the first time, the concept of union territory constitutionally comes under the 7th Amendment, with other amendments under the 7th Amendment. But union territory is given a separate treatment and not the treatment which is given to other federating states. So kindly see. Article 1, this is now post-amendment. India, that is Bharat, shall be a union of states.
1 minute. Which page?
I'm sorry, page 12, para 30. This is reproducing, the Article 1 post 7th Amendment, which was based on the report of Justice Fazal Ali Commission.
Yes.
India, that is Bharat, shall be a union of states. The states and the territories thereof shall be as specified in the first schedule. In the first schedule, there was an amendment where Delhi and others were shown as union territories, rest federating states. The territory of India shall comprise the territories of the states, the union territories specified in the first schedule, and such other territories as may be acquired. We were very, very ambitious, even at that time, that we might acquire some more territories, which of course we did acquire, not in the sense of invasion and acquire, but Sikkim came in 74. Thereafter, I have given in a tabular format for your Lordship's convenience what happened in 7th Amendment, pre-amendment position on the left column and post-amendment position on the right column. But your Lordship will kindly come to page 21 direct.
Yes.
Lord, this may kindly be read a little closely. Your Lordship knows, my Lord, the provisions of services is made in part 14 of the Constitution of India. Part 14 came to be amended by 7th Amendment. That is the Lordship would find at 308, the bottom foot of page 21. Left hand side is pre-constitution, right hand side is post. Interpretation. In this part, unless the context otherwise requires, the expression state means a state specified in part A or part B of the first schedule.
Page 21.
I'm sorry, your ladyship, it is page 21 at the foot, article 308, which is the first article in part 14 of the Constitution. The heading is services. Services of union and the states. Why, my lord, I show this for 3 reasons, which I'll, my lord, assist your lordship with subsequently. Lord, before the constitutional amendment by the 7th Amendment, interpretation was in this part, unless the context otherwise requires, the expression state means a state specified in part A or part B of the first schedule, meaning thereby, even before the Constitution, for part C states, there was no separate service, contempt, which now becomes steril. It was only for the federating states. Now, when the Constitution was being amended under 7th Amendment and the concept of union territory was being introduced, if the framers of the Constitution by the Parliament wanted to have a separate union territory service, it would have done so, because This is amended simultaneously. Seventh Amendment introduces union territory and also amends 308. Now see what is the amended provision of 308. Right hand side. Interpretation. In this part, unless the context otherwise requires, the expression state does not include the state of Jammu and Kashmir. The state as defined under Article 1 under the 7th schedule, that is federating state. Only exception, Jammu and Kashmir for reasons which were prevailing before 2019. Jammu and Kashmir was always used to be excluded. Meaning thereby, the very amendment which introduces union territory does not introduce the term union territory in the chapter which is under the heading of services under the union and the states. So there is no contemplation of a separate service for union territory. Now, my lord, 309. My lord, let me read the pre-amended provision. Recruitment and conditions of service of persons serving the union or a state, subject to the provisions of this constitution, act of the appropriate legislature may regulate the recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of the union or any state. Here, my lord, because of 308, state would necessarily mean federating state, not union territory. Nothing prevented Parliament to say so. Now, proviso is relevant and will give guide, my lord, assistance to your lordships. Why? Provided that it shall be competent for the president or such person as he may direct in the case of services and post in connection with the affairs of the union. Lord, UT is affairs of the union, first of all. It's an extension of the union, but leave it at that. Next. And for governor or Rajpramukh of a state or such person as he may direct in case of services and post in connection with affairs of the state to make rules, etc. Why not I am highlighting? Rajpramukh was only for part A and part B states. There was no Rajpramukh for part C states. When the constitution framers, my lord, I'm sorry, the parliament amends the constitution, introduces union territory for the first time by this very amendment. What it says, my lord, it doesn't say, it could have logically said it intended to introduce union territory to have a separate service. That president for services for the officers under the service of the union, governor for services under the state, and administrator for the purpose of services under the UT. Kindly see, my lord, what it says. My lord, right hand side proviso. Provided that it shall be competent for the president or such person as he may direct in the case of services and posts in connection with the affairs of the union, and for the governor, the Rajpramukh word is deleted because now A and B states have gone. It became federating states, but no introduction of administrator. And I'll show administrator also comes along with UT by this very amendment. Governor of a state or such person as he may direct in so and so. Now, please see, my lord, in this very amendment, my lord, at page 230, my lord, page 30. The same amendment, 7th amendment, which introduces union territory, also now provides for administrator and does not include administrator in services, does not include union territory in services. Therefore, my lord, my lord Justice Chandrachud, my lord, the Chief Justice of India, then my lord said that you will have to read the entry contextually, whether it was ever intended to be given to union territory. And therefore, the word used in 239AA is insofar as the matter is applicable to union territories. Plural, I'll come to that. That's a separate limb of argument. Lord, kindly see. Unamended 239. Administration of Part C state of the first schedule. Lord, the title makes it clear that Part 14 under the heading of services would not apply because it applies to states. And earlier it used to apply to A and B states. This is for Part C.